enough. I'm done. Either you take me to go piss, or I'm done. No, take me.
Have a seat now!
Okay. Having heard all of this, how do you plead to the felony battery charge?
No.
No contest?
Yeah.
Okay. And you understand that you're giving up all of the rights set forth in this plea agreement, including the right to a jury trial?
Yes, ma'am.
Okay. Has anyone forced you or coerced you to enter a plea today?
No, ma'am.
I will find that you freely and voluntarily entered the plea. Mr. Lambert, is there a stipulation to a factual basis for his plea?
Yes, Judge. And the information charges felony battery. There are three alternatives: either the permanent disability, permanent disfigurement, or great bodily harm. Our area of concentration is the permanent disfigurement.
Okay. And when you say our area of concentration, what do you mean by that?
That's where we're focused. I don't believe it's great bodily harm, and I don't believe it's permanent disability.
Okay. But, so just to confirm, you're agreeing there is a stipulation to a factual basis in the file? Okay. So I will find that there is a factual basis in the file as well. And then before I go any further, I'll allow you all to return to your seats, and then we'll hear from some witnesses today.
But one other thing is Mr. Kane has no prior criminal history, so he's waiting for prison.
Okay, thank you.
My name is Shana. It's Shanna McCree, MCREE.
And Ms. McCree, are you the victim in this case?
Yes, ma'am.
And prior to today, did you have the opportunity to review some video footage of when you were injured?
Yes, ma'am.
And is that you in that video?
Yes.
After your injury, did you receive medical care for the laceration to your forehead?
I did eventually, yes, ma'am.
And did you actually get stitches in your forehead?
Yes, I believe it was 7.
Okay. And were there any sort of like hospital bills or anything like that?
Yes, ma'am.
Yes, from your
From
treatment at
my,
the
yes,
hospital?
yes, for my treatment.
Anything after that?
Just the ambulance ride as well, yeah.
Okay. And beyond the laceration to your forehead, was there any head injury?
I don't recall, no, I don't believe so.
Okay. So it's just the laceration and the stitching to your forehead?
Yes, ma'am.
And did you actually have some bruising afterward as well?
Yeah, both my eyes were black and blue.
Okay. And I'm going to show you this exhibit. Do you recognize your sword from that photograph?
Yes, ma'am.
And when was that taken?
That was taken the day after, I believe.
And in that photograph, you see a mark across your forehead.
Mhm.
That's like the laceration.
Yes, ma'am.
Okay.
Yes.
And a stitch you put
At that time, yes.
Okay. Obviously, you got the stitches were removed. Have you had any scarring?
I have.
Okay. Do you still have some scarring on your forehead?
Yes, ma'am.
Okay. I know this is the judge is right next to you. If you can show her while you're popping up.
It goes from here all the way down here, and there's like an area here that's raised that was not there before.
How many inches?
Maybe 1.5 inches, 2 inches, maybe.
Yeah, and you said it's kind of raised right here. Where
There's an area right here that is kind of raised, which was not there before.
And you mean like the skin is raised?
Yeah.
Off right there.
Yeah, it's on the left-hand side, kind of right around there, I believe.
Right around your eyebrow?
Yes, ma'am. I think right above my eyebrow.
Can you tell us about that? Like having that scar, it's kind of in the middle of your face. How
Yeah.
has that been for you?
I have people ask me what happened all the time. Whenever I take pictures, it's visible. I see it like plain as day. I think about when my son gets married, pictures, it's just gonna be there, and it's just a constant reminder, and it's a disfigurement. I mean, I'll have it for the rest of my life.
Does that bother you?
Yes.
Well, you know we're here today for sentencing. I kind of explained that to you, is that right?
Yes, ma'am.
And is there anything that you'd like to say to the judge about what you would like to see happen today?
I would like to see him, of course, no longer be a police officer. I think some jail time is appropriate, and I hope he gets some anger management or some kind of evaluation, you know, so he doesn't do this to anybody else.
Do you mind if I ask your client what he thinks is an appropriate punishment?
Yes.
Yes, you mind, or yes, I can ask him? Okay,
Let me
go ahead.
Judge, you respond to your question, what do you?
Okay,
Your Honor, I'm not an attorney by no means. I'm not I'm simply just a basic law enforcement officer at best. I don't know what parameters should be set for this, and I believe it's the court's best interest to determine that for myself. Like I said, I don't know what would be appropriate, what wouldn't be appropriate as set to the parameters.
fair enough. Okay. Anything else you want me to know?
I do have a family. I have 2 small children that depend on me, and I have one that's 5, he'll be 6 in a couple weeks, and I have a 7-month-old. My wife, she does work, but taking me out of the home is extremely detrimental to our finances. You know, I bring in more than 80% of the household income, and any time away from them, including just this week alone, it would set me back at least a month, if not more. But being out of the home at any additional time, we will lose our home. We will lose the things that we have, and it's not fair to her or my family to have to continue to try to support me somewhere else while they're trying to get their stuff together elsewhere.
Okay. And how long have you been in custody?
I turned myself in Monday.
All right. Why did you do that?
It was at the interest of the council. They told me.
Okay, don't tell me what your attorneys told you. That's confidential information.
Yes, ma'am.
Okay. Do you have any other questions for your client? Okay. And do you have any other witnesses to call? Okay. Was your client pleading simply to a felony battery charge, not as set forth in the information?
Well, no, ma'am. The statute is in the alternative. And the one that we focus on, because I don't see any great bodily harm. I don't see any permanent disability. Permanent disfigurement, I think, is the appropriate area.
Okay.
And that's one of the alternatives.
Right. And so I have that in front of me, but my take on it is by virtue of entering the plea to the charges set forth in the information, you're acknowledging that one of those 3 items does exist. Am I misinterpreting the nature of the plea?
Oh, no, ma'am. And what I was acknowledging was the permanent disfigurement.
Okay, but you're disputing that it exists or not disputing?
No, not at all.
Okay, understood.
And I think, Judge, so I understand what you're saying too, but with the score sheet, you know, that scoring of severe, moderate, and slight, I think Your Honor can still do judicial fact finding as that, even within the contest plea.
Yes.
But I do think, obviously, you know, that goes to that they're acknowledging permanent disfigurement, or one of those 3 can be used. Obviously, I would argue that, but Your Honor can still do judicial fact finding for purposes of the score sheet.
Okay, understood. All right, I was not understanding it was simply a score sheet issue, but I understand that now. Okay, so tell me, if you will, what the state is seeking.
Well, Your Honor, the defendant scores 19.5 months. That's with the victim injury points. So I think that's really the argument there. So, Your Honor, I don't feel like there's a, you know, obviously my argument, we get the moderate points and that there is a departure. So we would ask for the 19.5, and I think followed by any term of incarceration that Your Honor did, I think followed by a term of probation for the defendant to get a psychological evaluation, following recommendations, the anger management, the restitution. Obviously, he's already relinquished his certification, but I would just ask that that's also just in the order, Judge. I think it's already been done, but I would just ask that it's in the order. And restitution. And I know that the defense, and this is more towards my argument, but that they had, you know, he's engaged in counseling at this moment. That's what they provided to Your Honor, that he has been, I think, seeing a counselor since the beginning of the year, but I asked for more than that. That's what I think that we do still need that psychological evaluation. and follow any of those recommendations. And if that recommendation is to continue in the therapy, that's great. But if there's more, I think that that needs to be done as well. And obviously no contact with it done.
Okay, and what would he score if I found slight injury
He would
points?
not score.
Okay.
You would score.
It's still permissible, you could still.
Oh, yeah.
Visit your body. So I mean, that's really the argument.
Okay. Is there case law on that I need to review in your opinion?
I think so. I
Okay.
mean, I can argue today, but I know that we're just like putting this on right now. So that's why if you wanted to be briefed on it, I understand that.
Okay. And Mr. Lambert, is there case law that you would wish me to review as well?
Yes, I do have that case law. The other thing, Judge, that we would be arguing if the court were to find that it was a moderate injury would be that he has no prior criminal history. This is clearly an unsophisticated act. If you look at the totality from the time of the arrest until even the hospital records, even when she's in the hospital, her behavior and the contribution that her behavior made to it, it's not an excuse, it's not defensible, it's just that that's a component. He is remorseful. I can tell the court that it was within 24 hours of this incident occurring that Mr. Cannon became our client. One of the first things he requested of me was he had been shown the video. What he had testified, or not testified to, but what he was saying on the recordings, on the axons, was his belief of what had occurred. Then once he saw the video, had a totally different perception and wanted to contact Ms. McCree. And I told him absolutely not. He was prohibited from doing that because he wanted to apologize to her. And I told her he could not. He wasn't going to talk with anybody about this incident at all, except for in a protected manner. I agree with the state. I think there needs to be a thorough mental health evaluation and follow through that as far as it takes. And I think it'll take quite a while based upon the early stages of what has been unearthed. I also think that because he is susceptible to treatment for mental health, that is grounds too for the court to depart downwardly.
Okay.
Your Honor, I'm sorry, I had an argument as to the injury points and as to why this is objecting to a departure, so I didn't know if you wanted me to go into that today.
Yeah, please.
Okay, so injury points first, because I think that's the first kind of threshold that we need to get to even talk about departure. So I really, Judge, I think that it is judicial fact finding. You have a lot of discretion. It's an abuse of discretion standard, and there is no guidance or concrete definition in the code for severe, moderate, and slight. There's some case law for the record. Sturtz, Garcia, these states, they kind of just go with the term moderate. What does that mean? Not violent, severe, or intense, must be more than slight. And I understand that it is, a head laceration, and Your Honor saw those videos. We didn't play all of them, but I know you've seen, the videos. There was quite a lot of blood. The photographs show quite a lot of blood. She's bleeding from her forehead. Just the laceration alone and getting that treatment is enough to score moderate harm. It's something more than slight. It's something more than bruising. And then she had to be stitched. She had to receive medical care, and in some of the cases they talk about that. Was there any medical care? Obviously, she had to have the stitching, and showed Your Honor for the record, some scarring on her forehead. She testified that that's something that bothers her and something that she sees every single day. People ask her about that. Excuse me, Judge. Having a seat now and took her, as we saw in the video, and threw her. He did not try to sit her down. He threw her down towards the ground. That's where she hits her head on the wall, on the ledge. And as she was on the ground, on his body-worn camera, and then we heard him, he's standing over her and said, I said, have a seat. Standing over her as she's on the ground. And at that point, Officer Edmonds is the one that actually starts to help her up. He did not. They take her out of that intoxicated room, and you can see they took her into the actual cell with the photographs with the blood all over. We do know that she fell in that cell, and she was left there bleeding in the cell as he then walks out, and the other officer left. She went to go call the ambulance. Going back to what we saw, this was not a forceful, trying to get her down, just used a little too much force in trying to sit her down, and then she slipped. That is not what happened, right? He's standing over her basically saying, see, I told you, I said to listen to me. I think that further establishes what exactly happened and what he meant to do. Again, he did not do something where he meant to hurt her, but he did mean to throw her down. And it is evident that this was completely out of rage and out of anger. right? Violence out of rage and out of anger that is not justified. And the result of that, of course, which I already talked about, is this significant injury. I think it is significant to have a scar across your face. There's a lot of places that you can have scars that perhaps would not bother you as much, but that would be the one place that would probably bother anybody the most, because you see it every single day, and anytime anybody looks at you, they see it as well. All of that, Judge, I think is why can he depart? Yes, I think Your Honor can. But should you? I do not think that you should. Officer Cannon, he makes a phone call after this happened, and he calls the sergeant. He calls him, and immediately after lies to him. He was untruthful and said, I went to grab her and she pulled away and fell and smacked her head on the glass. He asked him again, what happened? And he repeats that. And he told his sergeant that. And in the 707, he told his lieutenant the same thing as well, and actually acted it out for him. So while he is saying that he is remorseful today, Your Honor absolutely can consider that and can depart. But when we're talking about should you, he was untruthful when this happened to help himself. This is the history that's provided to the hospital, as that she, was belligerent and she ran into a wall or something like that. And so that was the history that was provided. That lie was provided. I think that's something to consider. So those are some reasons I think that you should not depart.
Okay.
That's it. Thank you, Judge.
Thank you.
Judge, what Mr. Cannon said after the incident occurred is what he believed. Also, his sergeant, when he's on the phone with him, says it was all recorded, wasn't it? And he said, yes, it's all recorded. If you're lying, you got something that's been preserved. That was his belief at that time until he saw the video. And then once he saw the video, that's when he realized that, wait a minute, I don't recall that. And that's what when the counseling started. He's been in law enforcement for 12 years. The one counselor had dubbed it, PTSD, probably from law enforcement experiences. The other, with the psychiatrist and the counselor, has it as an explosive disorder. Either of which is a mental health disease that needs to be addressed. And he acknowledges that, and he has been seeking treatment. During the 20-minute observation, the court has witnessed Ms. McCree's behavior, and also that Officer Edmondson has to go over there and forcibly put her back down. None of this is appropriate, but certainly we expect more out of people than we probably should. We shouldn't say, well, because he's a police officer, then he's got to be better than the rest of us. All of us, too, is a human being. Again, when you look at the totality of this, it is indefensible. Giving up your law enforcement certificate, which was your livelihood, was a big deal. But he acknowledged that I shouldn't be doing this anymore based upon my behavior, and also seeking the counseling. Officer Cannon could not go into that cell where she was after she was placed in there, because males are not permitted to go into a cell alone with a female in there. The other female had left, so he could not go in there. He was the only one there,
okay.
And he's a male, and so he's prohibited from being in. So I don't know if the state was kind of intimating that she's crying for help and he's not providing her anything as a result of it. He can't. But again, I'm not here to defend anything that he did. It deserves punishment, and I concur that a condition of whatever the court determines.
What began as a moment of lost control has now become the central question in sentencing. How serious was the harm, and should Cannon receive any leniency? The scar, the video, and what happened afterward are all now under the judge's scrutiny. The decision ahead will determine how this former officer is held accountable.
Must be mental health evaluation and follow through with all recommended treatment.
Okay. Well, clearly there are a lot of records that I have to review that I have not had until this hearing, so I'm not going to be able to go ahead and sentence Mr. Cannon today. All right, we're set for sentencing today in State versus Cannon. And would counsel again state your appearances for the record, starting with the State.
Ashley McCarthy for the State.
Michael Lambert, Brian Lambert,
Okay. And Mr. Cannon is with us as well. I did review some additional records. It's jail medical records that the state sent over, and case law as well that the state had sent over. I additionally reviewed the case law that was provided by the defendant at the last hearing, and I told you all that I would give you a few more minutes today for argument if you wanted to take that time. And so I'll start with the state.
Yes, Your Honor, just to kind of review what we did on Friday, we had argued about the injury complaints. I provided that case law to Your Honor. Those were the cases that I had cited regarding judicial fact finding, kind of giving you a definition of slight, moderate, and perhaps severe, but really that it is by discretion of the court. It's an abuse of discretion standard. Regarding any departure, it is I just want to make sure I got this right, that they are moving for departure pursuant to an isolated, unsophisticated event for which he shows remorse, and that he's amenable to treatment, specifically I think the anger management, I'll let them put that on the record, that he's amenable to treatment. And for those two reasons, they are saying that they are able to, Your Honor would be able to depart if Your Honor put the victim injury points on there.
My understanding was, in addition to those two, there was mention that I should consider the behavior of the victim, which could potentially go to the third grounds for downward departure.
So, and that's what I'd like for the defense to clarify, Judge. They made an argument about that. I don't know, and perhaps they can point out what evidence they have of that and what case law would support that. The state objects to that. I believe Your Honor can depart pursuant to isolated, unsophisticated, for which he shows remorse. Again, we object to a departure that you should not depart. I believe that you can depart pursuant to that he is amenable to treatment. However, I object to that. I don't think that you should depart for all of the reasons that I stated on Friday in my argument. Pursuant to that last mitigator, if that's what they're arguing, I disagree. I do not think, number one, that there's competent substantial evidence of that. And number two, I do not think that there's case law that supports that. So I don't think that that's a ground for departure.
Okay, thank you, ma'am.
And the last thing, Judge, they had kind of insinuated, there's no evidence of this, but insinuated an argument that Mr. Cannon was not receiving proper medical care in the jail. He had been there about 2-3 days on Friday when they addressed that. And I'll let them address that and I can rebut that if needed. But again, I don't know if that's a movement for some sort of departure or what exactly the purpose of that argument is. But if it was something for departure, there needs to be actual evidence of that on the record that I would then rebut.
Okay. All right, Mr. Lambert.
Morning, Your Honor. Yes, it is that he is one of the reasons that he's amenable to treatment and that they don't offer that specialized treatment in the prison. They only offer it outside. One of the downward departure reasons that treatment would be for mental health, not just anger management, either explosive disorder or PTSD, depending on what they end up figuring out the mental health issue is. So yes, that is one of the reasons that she instigated. With regard to the slight evidence on that, that's all in the medical records that the court reviewed in the videos. It's just that attitude. It's not something that we're doubling down on, just pointing out. With regard to the case law and the points, the Lynn v. State case, Lynn had told the officer that he bit that he was HIV positive. That caused a huge issue with his mental health, with his family's health, with all of it. So it's kind of disingenuous to use that case as a comparator, but we do agree that it is within the court's discretion, but we do not believe it's moderate. But even so, it sounds like the state agrees that there is a reason the court can downwardly depart if the court chooses to downwardly depart. So we would ask the court to downwardly depart and make it a treatment-based probation where he can get the help he needs. Thank you, Judge.
All right, thank you. And Mr. Cannon, would you please stand up with your attorneys? So I do agree with the defense that permanent disfigurement doesn't always necessarily mean moderate injury. I don't find the Lynn case or the citing of the Lynn case by the state to be disingenuous. I think it is helpful. And in that case, the court pointed out that scarring, along with the potential HIV issue in that case, was enough for moderate injury points. And I do think moderate injury points are appropriate in this case here. And I think that that's within my sound discretion to decide. And the reason for that, the reason I'm making that decision is Ms. McCree has a 1.5 to 2 inch scar right across the center of her forehead. She had 7 stitches for that, and then I think we're 7 months after the injury when she sat here next to me, just a few feet away from me. It's glaringly obvious, and that's something she's going to have to live with unless she gets plastic surgery to get rid of it. But it's red, it's raised a bit, and it's readily available to anybody who looks at her, readily visible. So I am scoring the moderate injury points. That unfortunately means that the defendant scores 19.1 months DOC unless I find grounds to downward depart. Obviously, this is a tough case. And let's talk about the grounds for downward departure. And I saw Mr. Lambert nodding his head when I was saying that I thought one of the grounds was that the victim, Ms. McCree, was somehow an initiator or provoker of the injuries that were caused to her by the defendant. And I've watched all of the videos. Ms. McCree was highly intoxicated. She was verbally abusive. But that's your job in law enforcement, to deal with all sorts of people, including people that are hostile, verbally abusive, and highly intoxicated. She was, in fact, screaming and combative at the hospital and had to be given medication and restrained, as your attorney argued. That was after the injury, though, after she had lost a significant amount of blood and had this huge gash across her forehead. I don't find that there's grounds to downward depart. I don't think that that has been proven, and I don't think it would be appropriate even if it had been proven. Unlike the state, I don't think that this was committed in an unsophisticated manner. I do think it was an isolated incident and the defendant's shown remorse for it. But the reason I'm finding that it wasn't committed in an unsophisticated manner was because after the victim was injured, she was placed in a holding cell. I think ignored as best I could tell. Nobody attempted to tend to her or give her any kind of aid. And then there were lies to the supervisor about how it occurred. So I don't find that that was committed in an unsophisticated manner. I do agree with the state, though. The defense has proven that the defendant suffers from a mental illness that's unrelated to substance abuse or addiction, and the defendant is amenable to treatment. One of the mental health providers, I think, saw the defendant, it looked like only one time, and diagnosed him with PTSD based solely on his 7 years in law enforcement. I'm disregarding that opinion. I think that opinion it is not specific to the defendant. The other treatment was more ongoing. It started in January and continued through June. There was a diagnosis of intermittent explosive disorder, and I find that that is appropriate under the circumstances. I do find that you suffer from a mental illness that's unrelated to substance abuse, that you are amenable to treatment. I am going to consider, in addition, your lack of any criminal history whatsoever and the 7 years of public service that you've done through your job. And I want to be very clear, I am not downward departing because you are a police officer. I am downward departing because you have no criminal history, and I'm trying to treat you the same as I would anybody else under similar circumstances in a similar situation. So I am going to adjudicate you guilty. The reason for that is, as a convicted felon, you will not be able to own a gun, buy a gun, possess a gun, and that's important to my sentence. I'm going to sentence you to 6 months county jail. Madam Clerk, how much credit does he have? 11 days. Okay, you have 11 days credit. That's going to be followed by 2 years of probation, during which time you need to undergo a mental health evaluation and any recommended treatment. You will be required to surrender your law enforcement certification to the state of Florida, but I believe you've already done that, sir. And then I am going to order restitution to the victim, Ms. McCree. I'm going to reserve for 60 days to determine that amount. And so if it wasn't already done, Madam Clerk, I'm going to revoke his bond today. And then the court costs are $770 plus 100 costs of prosecution, 100 costs of investigation, and that'll be a condition of your probation as well. Like I do with everybody else, I'm going to waive your cost of supervision for 1 of the 2 years of probation. And that's to encourage you to try to complete the terms of the probation and terminate early at that halfway point.
In the end, Cannon was convicted and sentenced to 6 months in jail, followed by 2 years of probation, with mental health evaluation and treatment required. The case showed that accountability can happen when misconduct is reported, investigated, and brought before a court. But as the final outcome makes clear, justice depends on people being willing to act when the line is crossed.